My
Section 174 on behalf of accused number.
I am Ms. Mgabayi from Mgabayi Attorneys, and I confirm that I appear on behalf of Mr. Van Rijn in this matter. I further confirm that these are judicial instructions. Section 174 of the Criminal Procedure Act allows a court to discharge an accused person.
Ms. Mgabayi, you don't have to take me to what Section 174 says. You can go straight to your application on the basis that it is brought.
Thank you.
I think I'm well aware of what Section 174 says. You will have noted when you came here this morning that my Volume 2 was not on the bench. My Volume 2 of the TWE. And my registrar brought it in. I actually went to do the research on Section 174 last night and this morning. And I had a look at all the cases.
Thank you,
That's
my Lord.
relevant.
Thank you, my Lord. The defense will argue that accused number 2 has no case to answer on the following reasons.
No. The trial judge. Do you know who the trial judge was?
No, I didn't notice the trial.
The trial started on the 17th of September 1999 in a place called Springbok.
I focus myself.
No. You see, when one reads a judgment, I told you the other day, I'm going to ask you about the facts, but I can tell you about the facts. Because the trial started on the 17th of September 1999 in a place called Springbok. And do you know who the trial judge was?
No, I don't know, my Lord.
Ndim. It was me. Now, in the event that I find that portion of Mr. Pollis's statement corroborates Ms. Lombard, in that regard, then it can be evidence. I'm not saying it is, because remember the test here is may. You use the term prima facie. I don't see it in the text. I've seen it in some judgments, the term being used. I try to stay away from it, because as I understand the authorities, I mustn't look at prima facie evidence. In the old Law Society lead program, and I used to tell the young attorneys, don't get up and bring an application for a discharge if you can just close your case. Because when you get up for a discharge application, you must be so confident that if it's refused, I can close my case. Otherwise, you waste the court's time. You weren't one of my students.
Beg your pardon?
You weren't one of my students. No, but I hear you, and it's something one has to consider carefully, because yes, there's no duty on the accused to strengthen the state's case, and there's no duty on the accused to incriminate herself. And the court must look at it objectively. And
Judge Nathan for sure earned his respect, and he gives the example of, hey, you guys are out here saying Renz is not a credible witness, but what exactly did Apollos do? What exactly did Mr. Apollos do? Confirm one of the narratives by Renz. And I'm like, my Lord, I'm screaming, through the screen, like, my Lord, don't forget about the microwave. Don't forget about the time Renz is talking about the microwave. She's laughing. Steffi is laughing his head off. That is when I started to say, okay. Renz is coming through with some information. So all of a sudden now they're throwing her under the bus and saying she's not a credible witness. But they back up her stories. So you see what is happening here is that the defense has no defense than to attack Renz, the 205 witness, the state witness. That is their only option at this point. So it is definitely a developing story. But in the next clip, we are going to listen to the state, and hear what the state has to say with regards to the application by Miss Mgabayi. I saw all your comments. I saw all your comments, as well as Kelly, I almost said Renz, as well as Kelly's advocate and what they presented to the judge with regards to their application for a Section 175, they had no choice but to apply for a Section 174, Section 174, because I know the Red Pen gang is out there in the comment section ready to correct me anytime I make a slight mistake. But I stand corrected, okay? It's Section 174 because they have nothing else to do. Now, I'm not saying that the accused are innocent. I'm just saying that the defense team had a really tough case to defend. This is a tough one, but I feel they should have still represented their clients effectively, especially with Advocate Mkabai, who did not know that the very Springbok case she's bringing to my lord was actually set by Lord Ndim, Judge Nathan. That for me will go down in the history books as wow. How did you bring a case and not know who the presiding judge was? Not only did you not know who the presiding judge was, but that judge is sitting right in front of you. And he says, I'm going to tell you the facts of that case. The judge tried to give her so many hints, but you know what? I'm getting ahead of myself. Let's go ahead and listen to the state and hear what they put on the table.
But I want to hear you on the application for Ms. Smith. I'm sure you also went to look at the authorities. It's fairly trite by now what the test is. You've heard Mr. Sivanarayan and he honed in on that issue. You've also heard me on the holistic evaluation. What is your view?
Indeed, my lord, but may I just correct something? Lombard is not my surname. Lombard is not my surname.
Ms. Swanepoel, I apologize.
Thank you. No, on a lighter note, my lord, completely.
What? I believe there's a Home Affairs office in town. Yes.
My lord, yes, indeed. I'm not going to address you on the law. You understand and know the law better than anyone of us.
I don't know the law. I have to rely on going to check it up every time. I spent time last night to reflect on the evidence because I knew this application was coming. I was thinking it through in my mind. And I did go and look at the authorities, simply because I've learned a hard lesson with the Lupatka case.
I understand.
I thought I knew it all.
Nobody ever
does. I was
does.
horribly mistaken.
Nobody ever does, my lord. Nobody ever does.
And to realize then of when all of these old authorities like Shopping, like Mpeta and so forth, and there were a whole range of it, of cases, but they were all pre-constitutional era.
Yes.
And if one evaluate the application of Section 174 in a constitutional era, it's different.
Yes, indeed.
Because it impacts on the fair trial rights of the accused.
I think everything does, my lord. It doesn't matter which application it is. Section 35 will always be applicable and must always be at the forefront of any presiding officer's mind when evaluating the evidence. But, my lord, making it applicable to this specific case. And there I would like to differ from my colleague. You cannot only look at the evidence of Lourentia Lombaard in isolation. My respectful submission is, yes, I concede there is criticism against what she testified, and the court will carefully evaluate that. But, my lord, it's the state's submission that there is that golden thread of truth running through her testimony, even if there are unreliable aspects in her testimony. The golden thread is still there. My Lord, and I submit with respect that there's other evidence that corroborates her version. As my Lord correctly now pointed out to that first part in accused number 1's statement, so also there is in accused number 2. So also there's strong corroboration found in Stephen Kutsia's testimony, my Lord, setting up this whole idea of the transaction. And then we need to go back and look at what offence we are looking at. We are looking at trafficking in persons, which is it's on a complete different level of offence. When one looks at that offence, and specifically also the elements of the offence applicable there. My Lord, we must remember that when it comes to trafficking in persons, it is not a single act or a single happening that constitutes the offence. In fact, it is said, and that is also if one looks at the law, it is a process. Trafficking in persons happens through a process. And the purpose, and well, in this instance, we're dealing with a child victim. So we only have 2 elements. We don't have the third element. So we need the act and then the purpose. The means element does not need to be proved because we're dealing with a child. Section 11 of the TIP Act makes that clear. The so-called, or we refer to it as the defence section, section 11. So we're only dealing with 2 elements, my Lord. The first one is the act, what was done, and then the purpose of exploitation in any form or manner. My Lord, the means is not necessary to be proved here, although I submit that the evidence indicates that there is means, more specifically in the abuse of the position of vulnerability of the victim, her being a child and her background and the social circumstances, as the state had laid that evidence. My Lord, I submit with respect that this court needs to look at all of the evidence holistically. This purpose of this application is not to say whether the accused is guilty or not. That's not where we are. The test is whether there is evidence that a reasonable court, acting with caution, could convict. And my submission is there's sufficient evidence to, in fact, say that a court can come to that conclusion. My Lord, so with respect, I submit that the applications for discharge, both of them, should be dismissed at this stage, and that the accused, and then specifically Ms. Smith, should be called and put on her defence. Thank you, my Lord.
Yes, thank you. I am going to give my order, my ruling on this application. And I'm not going to give reasons for the finding. For 2 primary reasons. One is that this finding is in itself not appealable at this stage. Secondly, for the court to summarize all the evidence and draw conclusions therefrom, it might be premature, as that is not the way the court evaluates evidence. It might also be that it will impact by giving reasons the fair trial rights of both the state and the defense. But I am going to explain what the application is about. Because of the public interest in the matter and the public's right to know what's happening with the court process. So it is so that when a person is charged with a criminal offense, the state bears the onus to prove the guilt of that person beyond a reasonable doubt. Furthermore, as I've explained when I explained the Section 204 process to Ms. Lombard, nobody is obliged to incriminate yourself. And there is no duty on the accused person to supplement the state's case to prove your own guilt. There are certain considerations, which are considerations of fact and law, that a court takes into account at this stage of the case. And the test is fairly simple. That because the state charges the accused and bears the onus, if at this stage of the trial, meaning the end of the state's case, the court is of the opinion, and by saying that, it is clearly something subjective based on the objective facts before the court. So it's the view that the court forms of the evidence that there is no evidence that the accused committed the offense referred to in the charge or the offenses upon which that individual may be convicted of that charge. And all of this must be evaluated looking through the prism of a reasonable court. Whether a reasonable court, on the available evidence, may come to the conclusion that the person is guilty. If the answer is no, then, unlike as at the end of the case, where there's reasonable doubt, a person is acquitted of the charge, the law dictates that if the court comes to that conclusion here, the person is to be found not guilty. So there's a difference in that, the order as well. Now, I have an application from Mr. Van Ryn and Ms. Smith for them to be found not guilty at this stage of the trial. I've heard the arguments for the defense as well as the state. I had the opportunity to consider the evidence led up to yesterday afternoon, because there was nothing really this morning. This morning was a waste of time. I also anticipated the applications to be brought. I anticipated what the arguments were going to be. That's why Mr. Stephen could say that I've referred to all the cases that you would have referred to. I've also anticipated what the state's argument was going to be. simply because everything was before me already. And on the basis of the facts that's before me currently, and the application of the legal issues as I understand it, I'm not of the opinion that there is no evidence upon which a reasonable court might convene in relation to both of Mr. Van Ryn and Ms. Smith. And for that reason, the application for a discharge for Mr. Van Ryn and Ms. Smith is refused. Thank you, Mr. Adamson. I just forgot to mention, full reasons for this order will be incorporated in the final judgment, as it might be an issue that can be the subject of an appeal, or in the appeal, in the event that an appeal take place, where it can be one of the grounds of appeal that I should have discharged. So the reasons will be incorporated.
So let's talk about it. Drop a 1 in the comment section down below if you truly believed that they were going to get an honorable discharge and they were going to win their application. Their application for Section 174 was going to be granted. Do let me know in the comment section down below. But for those of us who clearly knew the judge was not going to discharge them, not understanding why the defense team even brought this forward, based on just what we've seen in the courtroom, especially after the judge admitted those confessions, which means the judge thinks they hold water in this case. So just to summarize, or should I say to clarify, the court says, hey, the state did their cross-examination, or should I say, the state did their argument as to why they should not be granted a discharge due to their Section 174 application. And immediately after, okay, when I say immediately, I mean in the next sentence, there was no adjournment, nothing. The judge came through with his decision and he says he already knew they were going to apply for a Section 174, aka I'm a very smart judge. I have many years of experience. I already knew where this was going, so I prepared myself. I took home volume 2. You see here on my desk, it is not visible. I took home volume 2 so that I could revisit some of these authorities, because I knew as well you were going to quote them, which is why Kelly's lawyer could not quote any authorities further, because he's like, my lord has already spoke about them. Like, I'd be a fool to try and go up against my lord. And we heard the state say, literally, we heard the state, oh, why am I struggling with this sentence? We heard the state say, I'm not going to address you on the law. You know the law better than everybody here, so I'm not even going to bother with that. But I have to say, they shouldn't be discharged, because there is, yes, Renz is not the best witness we could bring to you, but it is what it is. Okay, that's all we had. Okay, her story does hold some kind of substance, and the judge validates that as well by using the example of Buddha confirms what Ren says in one of her accounts. I, Mzansi Unfiltered, confirmed to you or reminded you that Steffi confirmed one of Ren's story with the microwave, unprovoked, laughing in there in the galley, okay, in the dock. He was laughing, meaning he did not give instructions to object and say, I don't know anything about a microwave. Ever heard the phrase deny? Clearly, not those three. They never heard of it before. including giving their legal representation instructions. I feel, in my opinion, I could be wrong, the legal representatives had very, very little to work with or to go by, and they had to be creative, and there's not much creativity that could be involved. At the same time, I think they too are like, but there's a child missing. Yes, I'm going to represent you, but where's the child? For real, for real. So I think they gave half-hearted effort, if I'm being honest, but I could be wrong. And this is my opinion, okay? This is my opinion. You heard the court, okay? Opinions are allowed. I don't know why people like to fight opinions, but you heard the court say, the court is of the opinion. So Mzansi Unfiltered is of the opinion. And it's the view of the court formed by the evidence presented to this court. There is no evidence. He says there is no evidence that the accused committed the offenses. But he can't give reasons. He can't give reasons yet because they're not yet done with the case. But should you guys decide to go to appeal, don't worry. In the final judgment, I'll include the 4 reasons. He has 4 reasons why he denied their application. And the judge concludes with, this application is refused. There is no evidence upon which a reasonable court might convict. Let me break that down. This is what the judge says. There is no evidence upon which a reasonable court might convict. It's not true. That's what the defense is saying, that there's no evidence that the court could convict based on this evidence. But the court is saying, nah. Don't count your eggs. Don't count your chickens before the eggs hatch. That's basically what happened. As well, the court says, the evidence that was presented in the morning was a total waste of time. And that is Captain Morris, who came all the way from Cape Town to play the video, which had already been played in court, except the one for Gayton McKenzie, which means the state is not calling Gayton McKenzie to come and give his evidence. So, yeah, I would have thought Gayton McKenzie would come, but I guess the state thought, nah, he's already held his kangaroo court over there on the Facebook Lives. They're not giving him an additional platform. So this is definitely ongoing. And then in the next video, we will talk about the defense's next move. I think I'll title that video, Let's Just Throw the Towel In. Let's just call it quits right here, right now. Let me know your thoughts in the comment section down below. If you made this far in the video, absolutely have my heart. Please remember to like, comment, and subscribe. I'll catch you on the next upload. Have a great day. Bye.